All right, everyone. It is the 8th of September, 2020. Hope everyone is doing well. We are here today as Mayor and Commission in quasi-judicial function to consider an appeal of an Historic Preservation Commission decision regarding a Certificate of Appropriateness, 165 Lakeview Street. And since it's a formal meeting, we do need to begin with a roll call. So I'll first ask the Clerk of Commission to call roll for us.
Davenport.
Here.
Parker.
Here.
Link.
Here.
Wright.
Present.
Denson.
Here.
Edwards.
Here.
Barrett.
Present.
Thornton.
Here.
Hamby.
Here.
We have a quorum.
All right. Thank you, Ms. Howard. I appreciate it. All right. I'm going to ask Attorney's Office participant Michael Petty to describe the order of events so everybody understands what we'll see happening and what will be part of this afternoon.
Good afternoon, Mayor and Commission. I know you have seen a couple of these, but they're not very frequent, so I just want to go over a little bit of information for you. As the Mayor already said, we're here today for a hearing on the appeal from a June 17th determination of the Historic Preservation Commission, where it denied the application of Tom Ellis and Sarah Ellis for a Certificate of Appropriateness for the demolition and reconstruction of a residential structure located at 165 Lakeview Street. Your role today is to act as a judicial appellate body. It is your job to review the record and first determine if the HPC abused their discretion. Georgia courts have found that as long as the action was in accordance with the law and that there was any evidence to support the HPC's decision, then there was no abuse of discretion. If you find that there was no evidence to support the HPC's decision, then you should find that the HPC abused their discretion and overturned their decision. If you find, however, that there was evidence to support the HPC's decision, that they did not abuse their discretion, then you have two options in that situation. You can either uphold their decision as they made it, or you can modify their decision if you think that's appropriate. Both the appealing party and any parties opposed will have an opportunity for public comment today as soon as I finish speaking. You can consider their arguments, but you cannot consider any new evidence that they present. So no new evidence, just arguments today. The appealing party has 10 minutes to present arguments in support of this appeal, with the appealing party arguing first. If the appealing party or counsel does not use the full 10 minutes, appealing party may allow others supporting the appeal to make arguments. Persons opposing the appeal will then have a 10-minute period to present arguments in opposition. And then the persons wishing to speak, again, they have to divide that 10 minutes up. And the opponents, after the opponents have presented their arguments, then the appealing party has a 3-minute rebuttal. Finally, I just want to remind you that historic preservation staff are here if you have technical questions about anything. And otherwise, I think it's time for the public comment.
All right. And so I think as Michael outlined, the appealing party has first opportunity for public comment. And so I would call forth the appealing party present to provide comment. And I believe there's a 10-minute window provided for this.
How are y'all tonight? Can you hear me?
Yeah, sure can. Thanks for coming.
Yeah, good evening. And thank you for allowing me to speak tonight. I don't know if you've all had I hope you all had a minute to drive by 165 Lakeview Street as it stands today. And if you didn't, I want you to know that this is an application where the house is completely built. We are going through the whole building inspections process. We are hooked back up to permanent power. The HVAC is on. We've gone through all the building inspections requirements. So we have a completed structure if you all get a chance to drive by it today. The original COA that we're discussing was approved in November of 2017 with a demo permit that was approved in February of 2019 and a building permit that was issued in May 2019. So we're talking about something with some considerable age. I'm here tonight to appeal the denial of the application for two reasons. One, on the same evening that the denial was issued for 165 Lakeview Street, a approval was issued for the house directly next door, 175 Lakeview Street, that was owned by the same family, was in the same state of disrepair, and was covered under the same structural engineer's report recommending that it was not a safe structure. And the second reason is that I believe that we performed all the tasks we stated that would need to be done in the demo application, and that the entire structure was not demoed, and that we had verification from staff that in the worst case situation, a structural engineer's report and evaluation of a structure that's not safe or serviceable was the only relief on a COA condition. And I don't know how much information you have or all the reports issued, but in the original demo application, it's not a complete demo application, but a partial demo application. We actually stated that we would be removing the complete addition, all rotten siding, framing, sills, joists, and replace the roof with all new materials. So I'm here tonight to answer your questions, because I'm sure you have some. By the nature of the way that this application was approved originally, which I was not the original applicant in 2017, we inherited this COA, but by the very nature, the foundation on this house was to be added. It was 8 inches were to be added onto the top of the foundation of this house. Given that, along with the structural inefficiencies, and the structural engineer's report laid that out clearly, and the demo permit laid it out clearly as to the intentions. I think that, we did exactly what we said we were going to do, and knew that we were going to have to do given the condition of the house. I hope you guys have all the information, the structural engineer report, and all the COA information, but I'm here to answer questions. In closing, I guess what we're requesting tonight is not the approval of a demo application, but the finding that we didn't actually need a demo application because we didn't demo the entire structure, and that we can continue working under the COA issued in 2017 is what we hope you find this evening. Thank you.
Thanks, Mr. Ellis. Is there anyone else in the chamber to speak this evening? All right, I'm going to go ahead and turn it over to any commission questions or input. All right, Commissioner Link.
Yeah, I have some questions. Why was a building permit issued in opposition to the COA?
So that'd be for Doug Hansford.
Yeah.
Mr. Hansford, you're on the call.
Yes, I am. Thank you, Commissioner Lynn. The building permit was issued in accordance with the COA. And a demolition permit was issued, partial demolition. And the problem we realized later in the process than we should have is that they went way beyond what was approved in their demolition. We didn't realize it immediately. That was a mistake on our part, but when we finally did realize that, we stopped work on the project. Of course, it's almost rebuilt at this point.
So, this is not the first time this applicant has been before this body for an appeal. And we seem to be between a rock and a hard place. I believe that the HPC was correct in their finding. They did not abuse their discretion. The guidelines are clear, and the original COA was clear that this was to be a partial demolition of the non-historic rear additions only, to allow for the addition of the new addition. The whatever happened on 165 is completely irrelevant. You know, whatever the condition was and whatever the findings of that engineer were are completely irrelevant to this issue in front of us right now. And the conformity, you know, of the actual final structure is irrelevant as well. I mean, we're here to decide on whether or not this demolition was improper. And I'd like to move that the HPC did not abuse its discretion, but we need to. We have no real recourse other than this applicant going before an actual court of law for misdemeanor violations. So I'd like to go ahead and move that we find that the HPC did not abuse its discretion and that we modify the appeal so that it does conform to the original applied for COA, which includes some brick facings on the chimney, additional railing on the brick front steps. I believe there's a double hung window at the southern side that should be replaced with this square transom window, and then a rear elevation window that should be a paired window. I move that we require that this structure be modified to be in complete conformity with the original approved plans. And I would ask the mayor that we immediately have some kind of committee address appropriate measures for retribution for developers that violate these Historic Preservation Commission rules and plans, appropriate ways of assuring that they are not repeat offenders.
So I've got a motion on the floor with some component parts that would have to be modified. Do I hear a second?
I'll second.
I've got a second. I think Commissioner Wright, I'll give you the second. And
No, I don't need the second. I just have a question.
Further, question.
Did Andy, Commissioner Herod need to go next since he seconded? I just want some clarification on the motion.
Are you looking for a full reading of the motion?
Well, I just wanted to make sure that it was correlated. Well, first, that Commissioner Link had said that what happens on 165 doesn't matter, but 165 is the structure under consideration right now. So I just wanted to clarify that we're talking about 165. It is a little confusing, and I wanted to make sure that the motion was in line with it. There was no abuse, but that the certificate of appropriateness would be issued after those four listed conditions were made.
Yeah, I believe I misspoke. I meant 175, the adjacent property that was completely demolished and that there wasn't approval for. That whatever went on there is completely irrelevant. We are talking about
165. Right. And I just want to make sure, since this, is an appealant thing, that was clear in the record, and that your motion is moving forward with the certificate of appropriateness after those four corrections. I think it was like 3A.5, 3D, 3B1. Those that were listed. Melissa, is that what you were listing?
Yeah, 3A5, 3D, 3B1.
Well, I just wanted to share my frustration with this process. It seems to me that there was a structural engineer's report that did go to the planning department that did get the demolition permit administered. So I think that there's some confusion with this, but I think that another thing that this brings forward with the windows and the little nuances for getting something that's certified appropriate, it makes it hard when we're trying to get neighborhoods to become a historic district when our Historic Preservation Commission has these frustrating opportunities for both the applicant and the cost for the applicant, all of the people that come before the HPC. And I think that we've all seen that when there's an appeal for it. But I think that the structural, am I correct? I guess maybe Michael would be able to answer that there was a structural engineer's report that was given to the planning department on 165, which was when the demo permit was permitted.
Commissioner Wright, I think what's included in there are reports for both of the addresses. I think that was provided to the building inspections department after the COA was issued, but Mr. Hansford may be able to, or maybe Mr. Lonnie, correct me on that.
That's correct, Michael. The original building permit included a demolition permit for demolishing part of the structure, and I think that was the parts of the structure that were added, so they weren't part of the original home. And so the contractor took down basically the whole structure other than maybe some foundation portions, is my understanding. And subsequent to that, he had a structural engineer come out and look at the structural elements that were already on the ground or in the dumpster, and he made a determination at that point that the structure probably should have been taken down, but it was after the fact. And we have not issued, to this day, we have not issued a demolition permit that covers the amount of demolition that was done. We're not able to issue that permit. Does that make sense?
It is. I understand why it's so confusing.
Are there any further questions for staff or for the applicant? Andy?
I don't have a question. I mean, to me, I don't think it's confusing. I think these developers knew exactly what they were doing, and they didn't really give two hoots about what the law was, and they wanted to make their money as soon as possible. And if it's a minor inconvenience to go to court and for a misdemeanor, then that was the cost of doing business. But I think it's a pretty crappy thing what they did.
Further questions or comment? All right, we have a motion and a second on the floor. Ms. Howard, can you do a roll call for us, please?
Davenport,
Yes.
Parker,
Yes.
Link,
Yes.
Wright,
Yes.
Denson,
Yes.
Edwards,
Yes.
Harrod,
Yes.
Thornton,
Yes.
Yes.
Hamby. 9 yes.
All right, thank you. All right, all business being complete for this appeal hearing, I will entertain a motion to adjourn.
Adjourn.
Second.
All right, got a motion from Commissioner Wright to adjourn, second from Commissioner Edwards. All in favor?
Aye.
All right, we stand adjourned. We'll see everybody at 5:30 for our normally scheduled work session. Thanks.